From the supplementary list under heading for mediation for the nationwide 2.0, item 5, second appeal 500/2015.
Let this matter be placed before mediation और NCO mediation 2.0 के कुछ recorded के 2.0 के कुछ the office is directed to place this case immediately upon receipt of the mediation.
Item 6, second appeal 482/2018.
Essay number 482 of 2018, the 11th counsel for the appellant states that the appellant is not ready for mediation. The case is otherwise ready for final disposal. Pose this case for final disposal on 12 तारीख? Yes, of course. 12 तारीख.
Item 7, second appeal 37/2025.
Interested in mediation? No. The 11th counsel for the appellant submits that the party is not ready for mediation. The case is otherwise ready for final disposal. Close this case on 17th of February. March. First of March. नहीं. First March तो छुट्टी है शायद. First March is Sunday.
10th March.
The 10th of March.
Sixth case at 10:30 is the first case. Item 7, second appeal 216/2018 from derivation.
They have already completed but and the receipt most probably noted on that. The other side took time, price. Then ultimately the receipt dictated the order partly. Then fixed. This case not where the appeal last appellate court have waited. That's what you are saying. Already quoted the order of the court not to terminate.
All have expired.
Yeah.
Wasim Mia.
Yes. Wasim Mia, then Miller. Wasim Mia.
Wasim Mia expired. then Muslim Mia expired and
Yes.
Suman Mia expired. Right? Three persons.
Yes, three.
But are they represented through their other? Is their interest represented?
No, you just see. Lordship has considered the.
I've written it, but I just want to know
No,
because
no. Lordship just see Yaqub Mia and Rafiq Mia are the two sons of late Ramjan Mia. They are the response number 1 and 2 in this appeal.
Juman Mia,
And so far, Basir Mia is concerned, he is son of late Aga
Mia,
Mia.
right?
And Juman Mia is son of late Ramjan Mia. So he is own brother of the respondents.
What was the suit for? What was the suit for?
Suit for declaration of right title interest
Yes, the appeal has
and
abated.
recovery of possession.
Because I am on behalf of the respondent also. And I seek time for finding the idea for vacating this claim.
So, the appeal has abated. You have not seen the last order? Yes? आपकी बात मेरे तक पहुंच नहीं रही. You have seen the last order? इतना casual क्यों है? Your appeal has abated. 3 persons have not been substituted. Yes?
So one respondent has been here on that on behalf of that respondent.
Which respondent? Is one number? Who you were the appellant before the learned court?
No, I succeeded in this suit. Thereafter, the appeal was preferred by the present respondent number 1 and 2 and the performer respondent.
You were the plaintiff.
I am the plaintiff.
Appeal was preferred
By the respondent, present respondent number 1 and 2, along with respondent number 6, performer respondent number 6.
appellants were the plaintiffs.
Appellants were the plaintiffs.
Yes.
Let's just see the present appellants were the plaintiffs and the suit was decreed. Let's see. And the
Suit
appeal.
was decreed, still the plaintiffs were the appellant.
Here, second appeal में हम जो appellant.
नहीं, first appeal में भी आप देखिए.
First appeal देखिए याकूब मियां.
Decree देखिए. Appellants, plaintiffs.
Let's just see the appellant for degree I have in.
I am there. Page number 23.
याकूब मियां.
Yes.
रफीक मियां.
Yes.
Appellants.
Plaintiffs.
Yes.
Yes.
I wish to know. Suit was dismissed.
Partly decreed.
Partly.
Suit was partly decreed.
Partly. And then it appeal was prepared by them.
वादी का वाद संसद दाल प्लॉट नंबर
you are the respondent first party in the title appeal. As per the decree, you will see just page 23 of the decree. Page 23, appellate court.
Yes.
Yakub Mia, Rafiq Mia, who are the second appeal when you respond warrant. They were the appellants plaintiffs. Then Osir Mia was one of the respondent, first respondent, and other appellants before the people were in second appeal, 2 to 9, who were also the respondents. And then Juman Mia and Munna Mia, Muslim Mia, they were the plaintiffs, but they were made pro forma respondent.
Okay. So basically, all the descendants of Ramzan Mia were the plaintiffs.
Yes, Ramjan.
All the descendants of Ramzan Mia.
Brothers. They are the brothers. They were not substituted by their legal heirs, meaning they were widow and sons. And this appeal was, regular appeal was filed in the year 2007, and it was decided on 4th of September 2017, in between the dates of it, in 2008 and 2010, as per the IM filed for substitution. When we have mentioned after service of notice when it was reported, then we filed the title.
Just a moment. The suit was partly decreed.
Partly.
The appeal was filed by the plaintiffs.
विवादित प्लॉट 352 रकबा 2 डिसीजन जमीन जिस पर वादी का घर है तो छोड़कर खारिज किया।
That's right.
So they lost in this suit except in the plot number 3.
Right.
We didn't challenge this.
What happened in the first appellate?
That is not first appellate court.
Yes.
You just see page 12 on pass. The judgment was set aside. You just see page.
And the suit was decreed as per relief.
Suit was entire suit was which is under challenge by us. Page 22.
That's right, absolutely.
Find the dismissal of the suit by the impugn judgment at the class with the is not based on proper and legal conclusion, hence it is not sustainable and set aside. Appeal is allowed, suit is decreed as per relief sought.
And now it has come that the contesting
Occurrence in the court below and
contesting respondents in the court below. That appellate court. Some of them had expired.
Only one, Vasirmia. Vasirmia was the contesting respondent.
Yes, and pro forma respondents were had also
They
expired.
are the in fact plaintiffs. For 2 persons who died, they are the plaintiffs in the suit, but they didn't join in the appeal. So they have been included as pro forma respondent in the title. So the fact remains that the appeal abated in respect of 2 pro forma respondents and
One contesting.
contesting respondent. Vasirmia was one of the contesting respondents.
Yes. Sorry? You are representing respondent number 2. Rafiq Mia.
One is brother of Rafiq. Yakub Mia and Rafiq Mia are 2 brothers. Similarly, Iman Mia and Munna Mia and Muslim Mia are also the brothers of Rafiq. Own brother. all are sons of Ramjan.
So all these people, they died during the pendency of the appeal.
In
Now they
2008,
will have the liberty to proceed.
that is, the Honorable Coordinate Bench granted such liberty in the other case, which has been noted by us.
Right? You have your liberty to proceed. Second appeal number 216 of 2018. The Learned Counsel for the appellant has referred to the order dated 12th of January 2026, wherein it has been pointed out, it was recorded that Bashir Mia, who was contesting respondent number 1 before the Learned First Appellate Court, and 2 pro forma respondents in first appeal, namely Duman Mia and Muslim Mia, expired on 16/3/2008, 2008 and 13/11/2008 respectively. The Learned Counsel has submitted that the suit filed by the plaintiffs was decreed only with respect, the suit filed by the plaintiffs was dismissed except in connection with plot number 352, area 2 dismal, on which the plaintiffs were having the house. He submits that the plaintiffs were the appellants. The 2 plaintiffs, that is Yaqub Mia and Rafiq Mia,
Sons of
both sons of Ramzan Mia, were appellants before the Learned First Appellate Court. And Jumman Mia, Munna Mia, Muslim Mia, all 3 sons of Ramzan Mia were pro forma respondents and second party before the First Appellate Court. He submits that the contesting defendant Basir Mia had expired.
Dependent of the respondent number 1.
The contesting defendant number 1
Respondent.
and respondent number 1 before the Learned First Appellate Court had expired during the pendency of the appeal, and 2 other persons, namely Duman Mia and Muslim Mia, had also expired during the pendency. He submits that the first appeal itself had abated.
Title.
The title appeal itself had abated,
Due to
and
non-substitution.
due to non-substitution, and therefore the impugned judgment is a nullity in the eyes of law.
Appellate.
The impugned appellate judgment is nullity in the eyes of law, and consequently the present appeal also cannot proceed. He submits that
They took place reliance upon 2005 6 SCC, which has been quoted in the
he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2005 or bracket 6 SCC 300, and which has been followed by this court in second appeal number 112 of 2021. The Learned Counsel has also submitted that since the first appeal was allowed and the suit was decreed as per the relief by the Learned First Appellate Court, it can still be open to the respondents hearing who are representing the plaintiffs to take steps as per law. To have the decree reopened and to have the legal representatives of the aforesaid 3 persons brought on record. the learned counsel for the respondent number 2,
Respondent
Rafi
Ansari.
Rafiq Ansari, who was also one of the contesting respondents. He was contesting respondent, contesting defendant. No.
Contesting apparent in contesting respondent number 2 here in this appeal, and I was one of the appellants.
Okay. Rafiq Ansari. Yes, who was one of the appellant before the learned first appellate court.
Despite service, respondent number 1 here in this appeal did not use to appeal. Yeah,
Does not dispute this fact that the aforesaid 3 persons had expired during the pendency of the first appeal. In the order dated 17/8/2023 itself, it was recorded that respondent number 3, 5 and 6 had expired and it was also observed that this appeal had abated against respondent number 3, 5 and 6. Considering the fact that considering the nature of suit and the fact that the aforesaid 3 persons had expired during the pendency of first appeal and Basim Mia was one of the contesting respondent, who was also one of the contesting defendant in the suit. इसका बेटा तो है सब बसीम मियाँ का, सागर मियाँ एंड असलम मियाँ. Substitution नहीं हुआ, but the interest is substantially represented.
But no step was taken.
May not be taken. The law is well settled if the interest is substantially represented. On account of substitution.
The sons of Mia.
They are already there on record. हम अवेट नहीं करेंगे.
They were on, but it is not that prayer could have been made for deletion.
Maybe. अवेट नहीं करेंगे. Nullity नहीं हो. And so far as the others, the sons of Ramzan Mia are concerned, they are already on record.
Sons, not they are the brothers, but they are not the legal heirs, because the legal heirs are the sons and daughters. Widow. Brother cannot be the legal heir. Obviously not. So far Basim Mia is concerned, yes.
He is represented by his sons.
By two sons.
By two
Yes.
sons.
That is not respondent apparent number 5 and 6.
Yes.
But so far, the two other persons are concerned, who are the plaintiffs and appellants. Should have been apparent, but they joined as pro forma. Obviously, they have not been represented by any person. The appellants in the court below cannot be their legal heirs. They are not the sons.
this court is of the considered view that the appeal cannot proceed. Accordingly, this court holds that the impugned judgment passed by the learned first appellate court without substituting Bashir Mian, Juman Mian and Muslim Mian. Accordingly, this court is of the considered view that the impugned judgment by the first appellate court is itself a nullity.
Dated 4th September 2017.
Dated 4th of September 2017, passed in Title Appeal number 118/2007. It is made clear that this order will not stand in the way of the respondents.
Number 1 and 2. Who are here?
Respondents number 1 and 2, who were the appellants before the learned first appellate court.
The respondent number 2 is having all the documents of the language.
In their way to take appropriate steps as are permissible under law before the learned first appellate court, to have the decree reopened and to have the legal representatives of the aforesaid deceased persons brought on record before the first appellate court.
If advised, if so advised.
Open matlab if so advised ही होगी. In view of the disposal, बस बाकी तो सब आइए है आपका.
बाकी इससे हम respondent number 2 से ही फिर मसाले हैं. तो इसमें पहले परफॉर्मर respondent बना.
क्या बोलना चाह रहे हैं?
बस हम सिर्फ एक ही बात को सिर्फ
ठीक है आपका.
एक लाइन जो सोलोरिटी के बना है, एक लाइन ऊपर में लिख दिया जाए. After service of notice, the respondent number 1 did not appear, choose to appear. The learned
In spite of service of notice, the respondent number 1, Yaqub Mian, has chosen not to appear. That's all.
Yes.
Your IA is pending. The second appeal is accordingly dismissed.
From supplementary list, rating for final disposal, fifth item 1, second appeal 182 of 1991.
पास ओवर नहीं कर सकते ना? ऐसे कैसे पास ओवर करें? तो हम क्या करें बताइए? नहीं आप शुरू करिए अपना फाइल खोलिए और पढ़ना शुरू करिए. ऐसे नहीं होता है. ओपन योर फाइल. कहाँ है आपका फाइल? हम बहुत कॉस्ट के साथ एडजस्ट कर देंगे मैडम. इसका क्या मतलब है? राइट? आपके टाइम टेबल के हिसाब से हम लोग का केस नहीं चलेगा ना. कौन से कोर्ट में ऑन लेग्स है बताइए? किस कोर्ट में ऑन लेग्स हैं? कुछ नहीं पता है. इसी ग्राउंड पे डिस्मिस कर देते हैं आप. एडजर्न कर देते हैं 1 लाख रुपए कॉस्ट के साथ. कॉस्ट के साथ एडजर्न करेंगे. बताइए क्या पास ओवर? ये केस इसी के लिए फिक्स्ड है. पास ओवर का क्या मतलब है? दूसरा अभी तक पहुंचे नहीं है कोर्ट, है ना? राइट? पास ओवर होता है कि दूसरा कोर्ट में बिजी है तो चलो ठीक है पास ओवर. उनके हिसाब से कोर्ट का टाइम टेबल नहीं चलेगा ना। वो 12 बजे आते हैं तो हम लोग भी 12 बजे कोर्ट करें, ऐसा तो नहीं है। कितना देर में टेकअप करें ये बताइए। हाँ, फोन से संपर्क करें।
बोले कि हमारे
पास ओवर कैसे कराएं? आप कोई टाइम बताइए ना। ठीक है, ये जो तरीका है ना, ये सही नहीं है। ठीक है, फिर बोलेंगे कल कंटिन्यूटी में सुनने के लिए, तो बोलेंगे कल हम है नहीं। ठीक है ना, ये सब कहानी करके हम लोग जज बने, इसलिए हम लोग को मत सिखाइए। जितना ये सब कर है ना, देखिए आगे रिकॉर्ड।
जब तक फाइल आती है तब तक हम अपने मेमोरी से जो है।
हाँ, आप तो सेकेंड अपनी मेमोरी से बहस कर सकते हैं, करिए। आई विल नॉट स्टॉप।
ओरिजिनल प्लेंटिव जो है वो भी नहीं है, ओरिजिनल डिपेंडेंट भी नहीं है। ओरिजिनल डिपेंडेंट नंबर 1 के एस जो है वो अपरेंट्स है।
जस्ट अ मोमेंट। एक ही डिपेंडेंट थे ना?
एक ही
ओनली वन डिपेंडेंट।
वहाँ डिपेंडेंट 3 थे। Dependent number 1 is a person who is said to have executed the agreement, and 3 is a power of attorney holder. 3 sold the land to 2. They have got a separate case. They'll be asking to separate. Yeah. Presently, though इसमें development हो गया है, in the case there is a scheduled area regulation case filed by one tribal against us, and that case number I will be giving. एक earlier भी हुआ था 93 में भी, और दूसरा अभी भी हो गया है। They were added by Sakiru Independent.
So the appellant is the legal heirs of defendant number 1.
Yes, defendant.
Jagdish Kishore Pathak.
Jugal Kishore.
Jugal Kishore.
Jugal Kishore Pathak, his son, they are grandsons.
Okay, then. Suit for specific performance of contract.
Suit for specific performance, and presently there is an SAR case for this land, for the restoration of the land filed by tribal.
We are not concerned with that.
Not concerned बात नहीं है, this is tribal land and I don't know whether it can be transferred.
आगे बताइए।
आगे ये है कि the plaintiff from para 6 to 9 of the plaint has pleaded his readiness and willingness apart from the statement given in para 13.
6 to 9 and 13.
6 to 9 and 13. 13 relates to, says that it's a cause of action on 18/9/1982. He enters into an agreement, that is the date of cause of action, and on all subsequent dates, देखा जरूर, and all subsequent dates when he offered to perform, but the the defendant refused to register the deed. There is no date mentioned by 13th, and he have no dates that the date on which he mentioned he approached the defendant, the dates on which he refused. Anyway, the cause of action was made as an issue number 3. Since this cause of action itself is something in relation to the readiness and willingness, therefore, the issue number 3 was not decided by the trial court or by the appellate. You kindly judgment देखा जाएगा. Issue number 3 का judgment पे कोई भी findings नहीं है. Where he says that his cause of action arose on dates on which he offered to perform and the defendant refused to register it. That should have been a finding one.
Issue number 3 was cause of action.
Okay. Cause of action, but the language what he says on 18/9/82, the cause of action arose, the date of cutting the candidacy. On 18/9/1982, the cause of action arose. Hello.
Really? I've seen it.
And on subsequent dates, the dates are not given. What the cause of action is exactly in the nature of readiness and willingness. That is why I am saying that para 6 to 9 and 13 may be read together for the purpose of coming to a conclusion whether the plaintiff was ready and willing to perform this part of the contract or not. Now, the plaintiff himself says, plaintiff is DT.03, himself says that the defendant को आने जाने में तकलीफ तो रिटायर कर गए थे, रिटायर करने के बाद वो वहाँ नहीं रहते थे, हजारीबाग में नहीं रहते.
Which paragraph of PW3 are you referring? Evidence दिखाइए.
आप कह रहे हो पैरा 9
Just a moment.
PW2 का पैरा 9
PW3 बोल रहे थे.
जी, लेकिन अभी उनको PW2 का पैरा 9 मिल गया, उसमें वही सेम चीज.
पहले PW2 का पैराग्राफ. Who is PW2?
जी, Google
Who is PW2?
PW2 is the introduced witness whose name is not there in a witness, but he has proved the agreement. देखा जाएगा PW1 जो है, एक मिनट में थोड़ा सा इंटरप्ट कर रहे हैं, बीच में बोल रहे हैं. PW1 एग्जामिन होने के बाद उसको एक्सपंज कर दिया गया है. 2996 को उसका गवाही दी. On the next day, PW2 comes. He is not a named witness. He admits that उसको सामान नहीं मिला था. He comes on his own on the saying of the plaintiff, and he proves the exhibit 2. We had objected to it. The order sheet dated 3/9/19.
PW2 को क्यों एक्सपंज कर दिया?
जी,
PW1 को क्यों एक्सपंज कर दिया?
ये हम नहीं कह पाएंगे, लेकिन लिखा हुआ है में एक्सपर्ट. देखा
क्रॉस एग्जामिनेशन नहीं होता है तो एक्सपर्ट
जी, फिर भी जानना तो जरूरी है ना.
वो एक स्क्रीनशॉट डॉक्यूमेंट ले आकर के एग्जीक्यूट किया था, जिसको हटा दिया.
प्रति परीक्षण भी हुआ.
हुआ है, उसके ऊपर में लिखा हुआ एक्सपर्ट
हटाया गया।
हटाया, क्यों हटाया कि उसी का नेक्स्ट डेट PW2 was introduced, who is not a named witness in the agreement dated 18/9/1982, in which there were two witnesses. One is who named witness? एग्रीमेंट के एंड में देखा जाएगा, एग्जीबिट 2 के एंड में there were two witnesses named who are said to have signed Ramashish Pandey and Rajkumar Kabra. They were not examined. But PW2 on his own comes and proves exhibit 2. In para 4 we had objected to his proving this. लिखा हुआ उसमें para 4 में देखा जाएगा आपत्ति के साथ। मिला PW2 का para 4 सुबह से पढ़ दीजिए। खाली आइसोलेटेड लाइन पढ़ते हैं।
आपको जो मन हो पड़े, हम सुन रहे हैं।
नहीं, उसमें जहाँ पर जो लाइन में लिखा है ना, एग्रीमेंट को प्रदत्त 2 चिन्हित किया गया, सविरोध अंकित किया गया। Before an endorsement on an exhibit is made, Order 13, Rule 3 and 4 of the Code of Civil Procedure prescribe. Order 3 and 4. Order 13, Rule 3 and 4. Provided that the admissibility of the document, if objected to, will be decided by the presiding officer, which was not done. Order sheet dated 3/9/96 में kindly see. The order sheet even does not mention about it that there was an objection. Para 6 of the statement, that you permitted to read it. Para 6 of the statement.
जी अब जाइए।
I am proceeding on the
अब
line
जाइए।
because section 16C says, section 16C of basic relief act says that the plaintiff must avert and prove that he was always ready and willing. Always ready and willing पे जजमेंट है सुप्रीम कोर्ट का जो कहता है कि right from the date of execution till the decree is passed, he must show his willingness, continuous willingness Not that an isolated part of willingness will do, or an isolated part of readiness will do. So, para 6 of the print for kindly in the that the agreement dated 18/9/82 contained a stipulation that the sale has to be completed within 1 month before expiry of the stipulated period. The defendant came to the plaintiff and requested that he be paid a sum of rupees 1,000 as an advance against the consideration that the period of completion of the sale be extended till 17/11/82. The plaintiff and the defendant went to see Kashi Prasad Sahu, advocate, on 11/10/1982, and on instructions Kashi Prasad Sahu noted the payment and further advance sum and extension of time of the agreement dated such and such. Para 7. That the plaintiff categorically made it known to the defendant that he is ready and willing to perform his part of the agreement by paying the balance amount of the consideration money. The defendant, however, went on avoiding execution in a routine. Went on avoiding this execution. This is a routine statement of the sale carried in respect of the suit property on one pretext or the other. Then para 8. This para 7 what है? On plaintiff's insistence that the sale deed should be executed immediately, the defendant started pressing that the period be extended up to 30/11/1982. And thereafter it was extended. उनका thereafter यूं का टाइम नहीं ये करना चाह लेकिन para 7 में specific date on which he made offer to perform is not there. The place where he did is not there. We may kindly have a look to the law of contract in this regard, where the offers are to be made. Section 37, 38 and 48 I will be relying.
37, 38.
And 40 of the contract. Because section 9 of the Basic Relief Act says that all the defenses available. Apart from that, the offer is, it cannot be like writing an essay that I was ready and willing to perform my part. It has to be specific. It has to be clear. The kindly, there are the clear instructions.
देखिए पढ़ी
किताब में
हम आपको किताब नहीं दे सकते आपको पढ़ना है पढ़िए
किताब का जरूरत नहीं है. हम सेक्शन 31, 37 says that the parties of the contract should offer to perform, and if a party doesn't offer to perform, then the other party need not perform. 38(2) says such offer of performance should be at a proper place and proper time. And use section 48. 48
or 38
38(2) में है कि offer should be made at a reasonable place. 38(2) का 2 में है.
is that answer
मिल गया. Then 48, if we say that the place of performance was not prescribed in the contract, then in all those cases also the offer must be made at a proper place. 48 मिला मुझको. Even if the place of performance was not prescribed in the contract, it has to be performed at a proper place. What's a proper place? Where the defendant resides. It's an admitted fact that he didn't reside there. Then where did he go? There is no averment in the para 6 to 9 that the plaintiff ever went to Hazaribagh to perform his part of the performance. Or he wrote any letter to the defendant number 1 that by sending by registered post or something. The exhibit number 3.
Suit property is located where?
ये
Suit property is also in Hazaribagh.
नहीं, सूट प्रॉपर्टी रांची में है. केस प्लेंटिफ का ये है कि वो रिटायर्ड हो करके कभी-कभी रेंट लेने के लिए आते थे, वो हजारीबाग में रहते थे. प्लेंटिफ ने रेंट में भी इस चीज को कहा है और गवाही में भी कहा है. Para 4 of the plaint का kindly listen. Para 4 of the plaint. Para 4 of the plaint का plaintiff क्या कहते हैं, हम कहाँ रहते हैं. जब kindly रहते हैं.
देख लिए.
Plaint को.
प्लेन की खोल के बैठे हैं.
Plaint का para 4.
वही खोल के बैठे हैं.
जी. The plaintiff says that the defendant resides in Hazaribagh and at the address given in the post-title portion. He used to regularly visit to Ranchi for the purpose of collecting rent. गवाही में कहते हैं कि उनको रेंट कलेक्ट करने में दिक्कत होती थी बाहर से आने जाने में. Therefore, the proper place according to me would be the address which has been mentioned about Hazaribagh, which the plaintiff was aware. He should have done something to show his bona fide that he really either visited Hazaribagh or sent a notice to Hazaribagh. In this connection, exhibit 4, exhibit 3 does not mention any address at which the notices were sent to me. Exhibit 3, kindly visit. इसके नीचे में एड्रेस नहीं है. एक्टिविटी के नीचे में कहते हैं कि रजिस्टर्ड पोस्ट से भेजे थे. लास्ट पेज एक्टिविटी 3 का कॉपी 2 मिला.
Yes.
जी
Yes, it's here.
एग्जीक्यूटिव का लास्ट पे OP2 नंबर 1 जुगल किशोर पाठक नो एड्रेस राशि का नहीं और उसको कहते हैं ये 30 तारीख को हम रिसीव कर लिए और उसमें देखा जाएगा इसमें फर्स्ट पेज जो नोटिस है उसमें नोटिस पाया जुगल किशोर पाठक Anyway, the conduct of the plaintiff. We have admitted that after the suit was filed, after the agreement was entered into, he stopped paying rent. Then the findings given by the trial court in para 10 of the judgment mechanism. और उस टाइम जो बोल रहे थे जो PW3 का पैरा 14 प्लेंटिफ यहाँ पर कहाँ रहता था मिला जुगल किशोर पाठक दुर्गा मंदिर में रहते थे पता नहीं कहाँ दुर्गा मंदिर now the findings of the trial court in para 11 and para 9 to 11 of the appellate court में pending
Para number 9 to 11.
para number 9 to 11 of appellate court and para 11 of the trial court
Para 11 of trial court. Para 9 to
11 of the appellate court
yes.
there is a finding given that the plaintiff was ready and willing to perform this part of the project. Always ready and willing, not ready and willing. Always ready and willing. How come this finding comes? Para 11 of the trial court judgment. अपलेट को जजमेंट देखेंगे।
आप जो बोलेंगे देखेंगे, ट्रायल कोर्ट देख लेंगे।
अपलेट कोर्ट जजमेंट का पैरा 9 to 11 पर हम रेफर कर रहे हैं और ट्रायल कोर्ट का पैरा 11। ट्रायल कोर्ट जजमेंट का पैरा 11 पढ़ देते हैं। After consideration of the entire oral and documentary evidence brought on record, I find that the plaintiff has paid rupees 2,000 on 18/9/1982, the date on which the agreement was executed, and the defendant was executed by defendant 1 in favor of plaintiff, and again 1,000 was paid on 11/10/82, while exhibit 2 by 1, exhibit 2 by 1, 2 by 2 and 3 by 1 clearly shows that the plaintiff was always ready and willing to perform the part. So therefore those exhibits will have to be seen. Exhibit 2 कैसे प्रूफ हुआ बता दिए हो। Exhibit 2 by 2 also shows that the address which is mentioned there is only of Hazari. Exhibit 2 by 2 kindly. 2 by 2 में ऊपर में लिखा है आई जुगल किशोर पाठक सन ऑफ सेकेंड बाय फेस प्रेसिडेंट रेजिडेंट ऑफ विलेज कारिडी माडा पीएस सेंटर है डिस्ट्रिक्ट हजारीबाग। रांची का कोई एड्रेस नहीं। इस एग्जीबिट को देखने के बाद लर्नेड कोर्ट ने ये कहा कि इस एग्जीबिट को देखने से लगता है कि प्रिंटिंग रेडी एंड विलिंग था, जबकि पूरे प्रिंट पूरी गवाही कहीं पर एक लाइन भी नहीं है तो वो हजारीबाग कबूल किया। एनीवे द अपलेट कोर्ट फाइंडिंग While appealing the appeal, the land council appearing on behalf of the appellate court submitted that the plaintiff had not pleaded and proved the readiness and willingness. जैसे एक चीज हम बोला बोले readiness and willingness को इशू बना नहीं था, ट्रायल कोर्ट में बना दो। जो इश्यूज है उसमें देखा जाएगा इश्यूज है ही नहीं। वो इशू है। The court in para 10 of the appellate court says that it is incorrect to say that the plaintiff has not pleaded readiness and willingness and has referred to AI 1971 Supreme Court where readiness and willingness is not to be treated as state jacket, क्योंकि इस पॉइंट पर हम ऑलरेडी बहस कर चुके हैं कि मंजूनाथ एंड टप्पा केस में ऑनरेबल सुप्रीम कोर्ट ने कहा था कि ये डिसीजन जो है पर इंपीरियम ऑफ द अर्लियर डिसीजन है।
ऑलरेडी बहस कर चुके हैं, कब बहस की?
तो जो स्टार्टिंग में उन्होंने एक ऑर्डर शीट ड्रॉ
नहीं, वो तो आपने तो बोला कि आपका सब बात नहीं लिखाया है, सब कुछ नहीं लिखाया है, तो उसमें हम भूल गए।
उसमें लेकिन ये वाली बात आई,
हम सब भूल गए उसके बाद। आपको जो प्लेस करना है आप अभी प्लेस करिए, क्योंकि उसमें आपने कहा आईएफआई किया कि एरर है, सही से रिकॉर्डिंग नहीं हुआ, छूट गई थी, एरर है, तो अब हम उसको कैसे देखेंगे? अब आपको जो प्लेस करना है प्लेस करिए।
ठीक है। तो ये फाइंडिंग जो है ये कंट्रारी टू सुप्रीम कोर्ट डिसीजन है, जिसमें ये डिसीजन को वाज हेल्ड टू बी पर इंक्लूजन इन
नहीं,
द
आप
केस ऑफ
हमको बताइए कौन सा डिसीजन क्या है,
अनुराग
आप प्लेस नहीं
अग्रवाल
करेगा
के-
तो कहाँ से पता चलेगा?
उसको डिसीजन को हम एक बार जो डिसीजन देंगे तो उसको फिर रेफर कर देते हैं।
नहीं, ऐसा थोड़ी होगा। बहस कर रहे हैं तो बहस के समय ना डिसीजन पेश होगा।
यहाँ पर एक चीज दूसरी दिखाई दे रही है। The reference at 2003 volume 10 SPC. ये भी सुपर स्टैटिक परफॉर्मेंस का केस था। पार्ट परफॉर्मेंस हुआ था, पार्ट परफॉर्मेंस नहीं हुआ।
Which paragraph are you referring to?
हाँ, there are several paragraphs जिसमें continuously ये चीज को लिया गया है। पैरा 13 में स्पेसिफिक रिलीफ एक्ट का सेक्शन को कोट किया गया है। पैरा 15 फॉर्म फिलअप 1 Form 47 and 48 of Appendix A of the Code of Civil Procedure prescribes the manner in which such averments are required to be made by the plaintiff. Indisputably, plaintiff has not made any averments to that effect, and that is in relation to the facts of that case. Now, para 17. The requirement to comply with the mandatory provision of Section 16 of Specific Relief Act came for consideration in section such. The plaintiff did not plead either in the plaint or in the subsequent stage that he was ready and willing to perform the agreement pleaded in the written statement. A suit for specific performance has to conform with the requirement prescribed in Form 47 and 48 of the first schedule of the Code of Civil Procedure. In a suit for specific performance, it is incumbent that plaintiff is not to set out an agreement on the basis of which he sues. He must go further, plead that he has applied to the defendant specifically to perform the agreement pleaded by him, but now the decision, the two judges bench decision of Chandok para 18, ये जो स्टेट जैकेट फॉर्मूला वाला है उसको ऑनरेबल सुप्रीम कोर्ट ने कहा पैरा 21 में 14 para 13 the decision which was relied upon by the trial court para 21 को जो there is also a decision of this court in such as Abdul Qadir versus Sashanka and Oyser were not referred to. And noticing this, R.C. Chandik observed that it was held in the R.C. Chandak section that the readiness and willingness cannot be treated as a state jacket formula. यही लाइन कोट किया गया है उस जजमेंट। So the findings of the Latin appellate court on the point of readiness and willingness by relying upon a decision which was per inferium of an earlier decision of Oyser.
In which paragraph the appellate court has referred to this decision?
Para 10.
Paragraph 10.
It is incorrect to say that the plaintiff has not pleaded and willingness AIN 1971 Supreme Court 1238 has been held that readiness willingness is not to be treated as a state jacket formula. यही लाइन को यहाँ पर ऑनरेबल सुप्रीम कोर्ट ने कहा कि दिस वाज पर
1968 सुप्रीम कोर्ट
जी
71 सुप्रीम कोर्ट
71 सुप्रीम कोर्ट वही 71 सुप्रीम कोर्ट का एससीसी वर्जन यहाँ पर नोट किया दैट इज चैडविक केस
कौन सा 71 सुप्रीम कोर्ट ये चैडविक केस
चैडविक केस जो था
जस्ट अ मोमेंट
उसके बारे में ऑनर पैरा 21 में लिखते हैं, there is earlier decision of the Supreme Court of this court in Abdul Khadir Rotter and Oisef Burgess were not referred to. However, in the earlier noticing Asif Chadwick, it was held such as the किसी meritorious and willingness to state jacket formula वाला word लिखा हुआ है. पैरा 17 में ओएसएफ वर्गीज के केस को ऑनरेबल सुप्रीम कोर्ट ने कोर्ट किया, जिसको 71 सुप्रीम कोर्ट ने नहीं देखा. As regards form number 47 and 48 of the appendix A of the Code of Civil Procedure. इश्यूज पर फाइंडिंग को जरा देखा जाएगा. इशू नंबर 3 का कोई फाइंडिंग नहीं है, वो भी इसी पर है. Now the findings of the trial court in relation to exhibit. Paragraph of the trial court judgment. The defendants have taken a plea in their written statement that the plaintiff has got an agreement for sale executed in favor of the practicing fraud, coercion, misrepresentation. The defendants have not produced any evidence in support of this fact. Now here I pause. The similar thing happened in one of the case, which is a reported decision of this honorable court, of the honorable Supreme Court. Thiruvengadam Pillai. इसका रेफरेंस है 2008 वॉल्यूम 4 एससीसी पेज 530 पैराग्राफ 19. नाम थोड़ा स्पेल करने में डिफिकल्टी होती है. Thiruvengadam Pillai. Here the case was that the defendant had said that the deed was not proper. Then the court said that the negative of a thing cannot be proved. No onus can lie on a person to prove the negative. The person who wants to say that it is a genuine agreement, it is for him to come and prove that there no fraud and coercion was placed. Para 19 में kindly visit. Pardon? The trial court has analyzed the evidence properly and has dismissed the suit by giving cogent reason. The first separate court reversed the wrongly placing the onus on the defendant. Its observation and the execution of an unregistered agreement was put forward. The plaintiff was denied by the defendant. It was for the defendant to establish the document was forged and concocted. यही चीज यहाँ भी किया कि आपने एविडेंस नहीं लाया. Is not sound proposition. Miller. The first appellate court proceeded on the basis that it is for the party who asserts something to prove that thing, and that defendant alleged that the agreement was forged, it was for them to prove it. But the first appellate court lost the sight of the fact that the party who propounds the document will have to prove it. In this case, the plaintiff came to the court alleging the first defendant has executed an agreement of sale in his favor. The first defendant having denied it, the burden was on the plaintiff to prove the first defendant has executed the agreement and not on the first defendant to prove the negative. बहुत मेहनत पड़ जा रहा है लोगों का रिटर्न नोट्स दे देंगे उसको इतना
नहीं आप अपना आर्गुमेंट कंप्लीट
देख रहे हैं बहुत लिखने में परेशानी हो रही है.
नहीं आपको कोई परेशानी नहीं है लिखने की आदत है मुझे
जी
लिखने की आदत है मुझे तो कोई परेशानी नहीं है आप अपना आर्गुमेंट कंप्लीट
जी एक डिसीजन और रेफर करना चाहेंगे 95 people subsequently followed recently also. क्योंकि specifically factor section 6 में always word है, just kindly खाली readiness and willingness नहीं, always ready and willingness.
रोज देखते हैं
जी
रोज देखते हैं
हाँ आप
मेरा बोर्ड 1 साल से चल रहा है ये सारे सेक्शंस अच्छी तरह से देखे हुए ऑलवेज है
$95 volume 5 SCC page 115. Now we will exhibit 2 by 1. We'll see the receipt. On a stamp document, exhibit 2 इसमें अविनाश चौहान का केस को हम लास्ट टाइम रेफर किए थे, लेकिन दूसरी रेफर कर देते हैं 2009 वॉल्यूम 2 एससीसी पेज 532 2009 वॉल्यूम 2 एससीसी पेज 532 and this 2024 decision GM Sahu 2024 volume 7 SCC page 719 also for this वाला decision मिल गया दे देंगे ये 2009 का है अविनाश चौहान और ये 2024 में ये वाला है ये पैरा 21 में
ये वाला 2009 का कौन सा वाला पैराग्राफ आप लोग 2009 का कौन सा पैराग्राफ रेफर कर रहे हैं?
ये
Which paragraph?
पैरा 14 Para 17, Parliament has in section 35 of the Act advisedly used the words for any other purpose whatsoever. The purpose for which the document is sought to be admitted in evidence to the extent thereof would not be treated as a relevant factor. इसमें collateral purpose को deal किया गया है. जेम्स साहुल में पैरा 21
GM साहब
वो 24 वाला
ये इसका खत्म हो गया 2009 का सारे पैराग्राफ्स
क्योंकि उसके बाद का फर्दर डिसीजन जब आ गया है 24 का
GM साहब ये तो आप नहीं दिए हैं
ये
GM साहब का जजमेंट अच्छी है इसका पैरा नंबर बताएं
21 says that the presiding officer of a court being authorized by law to receive an instrument in evidence is bound to give effect to the mandate of section 33 and 34. It retains the authorities to impound the document in absence of any objection from any party of the proceeding. Such an absence of an objection, this is your line here, such an absence of any objection would not close the presiding officer of the court with the power to mechanically admit a document that is tendered in admission in evidence. The However, once a decision such and such is rendered, be it right or wrong, तब 35 would keep on. लेकिन डिसीजन इसका कोई लिया ही नहीं लिया है. That is understand. The पैरा 10 of the trial court judgment was this would definitely get into 8 decisions to be here. तो लगा कि इसकी बात में पॉइंट को बहस की नहीं है। Fourth line. Correct.
Yes, please.
Alright. Besides that, I have already stated above that the defendant number 3 has filed a wakalatnama in the suit for himself, as well as for the constituted agent of defendant number 3 has filed wakalatnama for himself and as constituted attorney of defendant number 1. But no written statement has been filed on behalf of defendant 1. Ultimately, the case was fixed for ex parte on such and such. The failure on the part of the defendant number 1 to file the written statement clearly goes to show that the defendant number 1 admits the assertion made in this case. The execution of agreement such and such also misrepresentation is not maintainable at all. In this connection, the decision of the Honorable Supreme Court given in 2015, volume 12, SEC page 403.
ये कहाँ पर आप ये जजमेंट पढ़े हैं ट्रायल कोर्ट के जजमेंट में?
Third, fourth line only. As not produced, so starting is important.
वो तो हम पढ़ लिए, लेकिन वो जो आप जजमेंट अभी पढ़े इन दिस कनेक्शन, वो कौन सा जजमेंट है? और यू आर रेफरिंग टू अ
हाँ,
जजमेंट?
बिल्कुल।
अच्छा, वो आप पढ़ बताइए कौन सा जजमेंट?
2015, volume 12. SEC page 403.
2015 volume 12 SSC page 403.
403.
Yes.
Para 13. In a case where the written statement is not filed, the civil court has the jurisdiction to proceed under order at written. However, the orders are not required to be passed in a mechanical manner in exercise of powers contained in the such and such. In Balaji's Taneja, the court has led that in spite of admission of fact having been made by the party to the suit, court may still require the plaintiff to prove the fact which has been admitted by the defendant. This is also in consonance with such and such then court's section 58 of the Evidence Act. I need not refer to again the provision to this section specifically gives a discretion to the court to require to the facts admitted to be proved otherwise than by admissions such and such corresponds to the provision to such and such. In view of the above, it is clear that the court at no stage can act blindly or mechanically while enabling the court to pronounce a judgment in a situation where no written statement is filed by the defendant. The court has also been given a discretion to pass an order as it thinks fit or has alternative. This is also a position under Order 8 Rule 10 where the court can either pronounce the judgment against the defendant or pass such orders as it in view of the law. Para 14. The trial court has such and such in this to have 14 को ratio नहीं लेना तो सुनो हम समझें the plaintiff brought 4 witnesses to prove the fact. First witness was expunged, 3 witnesses remains. Out of this, one is the plaintiff himself. another is the lawyer drafted, and the third one, PW2, is an alien to the contract, comes, proves, goes. Now the documents are incidentally also four: Exhibit 2, 2 by 1, 2 by 2, and 3. These are the documents by which the plaintiff says that he was ready and willing to perform. Exhibit 2 is a contract which has not been proved in terms of law, and the objections were not decided. Exhibit 2 by 1 is an unstamped document which cannot be relied upon. Exhibit 2 by 2 is a document which shows that the address of the plaintiff was somewhere else, and there is no averment in the case that he has ever gone to that address to perform his part of the contract. Exhibit 3 is a contract where no address of the plaintiff is independent is given, but it is still claimed that on the date the notice was issued, sent by registered post on the same day, the defendant received the notice and gave the endorsed to the plaintiff. This is the way, and the plaintiff's conduct subsequent to the entering into the agreement. In the witness box, he has said that he stopped paying rent. PW3 PW4 para 8.
PW4 is the plaintiff.
G
PW3 is the plaintiff or PW4 is the plaintiff?
4. पैरा 8 का लास्ट लाइन इसमें लिखा है इकरारनामा के बाद किराया देना बंद कर दिया। इकरारनामा के बाद तथा वाद दायर करने के बीच में किराया अवधि में किराया नहीं दिया, मांगने भी नहीं आया। Section 20 of the Special Relief Act, the decision in favor of a person whose conduct is not equitable, the subsequent conduct is more reprehensible. In his contract, his status as lenient, he is changed, and he said that he has got the position as in part performance, he sold the position. 3 लाख रुपए में किसी को बेचे हैं, वो आकर के यहाँ एक ही कॉमन माल मेरे घर का उनका, और वो कॉमन माल को तोड़ देंगे तो मेरा घर बेपर्दा हो जाएगा, और रोज का झंझट होता है, दूसरा क्रिमिनल केसेस, सुबह केसेस, काउंटर केसेस।
ओके चलिए, अब आपको मैं इसका आप किनकी तरफ से परचेजर यानी अपीलांट हैं, अपीलांट नंबर
आइए
परचेजर फ्रॉम whom? परचेजर फ्रॉम whom? तो परचेजर नहीं हुए ना अभी तक, पावर ऑफ अटॉर्नी होल्डर।
No, from power of attorney, purchaser from power.
I already purchased.
आप बताइए ना भाई, आप किस डिफेंडेंट को रिप्रेजेंट कर रहे हैं?
Defendant number 2.
डिफेंडेंट नंबर 2
After filing.
एंड अपीलांट नंबर
Appellant comes. Here he was appellant. Appellant number 4.
अपीलांट नंबर 4, यस
Yes.
नाम बताइए अपीलांट नंबर 4 का।
Dinesh Patel.
आपने ये कब खरीदा? At what point of time did you purchase?
There was an agreement prior to agreement of the plaintiff, and I purchased this.
What was the date of your agreement? And what is the exhibit number? सर इतना स्लो मोशन में नहीं चल सकते हैं। आप सुन रहे हैं मेरी बात? एग्जिबिट नंबर बताइए। What is the date of your agreement and what is the exhibit number? That is the sheet anchor of your case. उसी का आपको पता नहीं है। Exhibit D, डेट बताइए। Exhibit B, डेट बताइए।
आठ 1982 by different number 2 in favor of different number, by different number 3 in favor of different number 2.
By defendant number 3 in favor of defendant number
2.
2.
And pursuant to that agreement,
The appellant who has argued, he was representing defendant number 1.
1 and
1 and 3. 1 and 3 का क्या संबंध? How is 1 related to 3?
1 is the real
1 is the real owner.
owner,
Okay.
and different number 3 is power of attorney
Power of attorney
of different number 1.
of defendant number 1. And defendant number 2 is
Considered to power of attorney of the
purchase power of attorney. His purchase is dated
purchase sale was executed on 20 of December 1982.
2012 1982,
82.
preceded by, and this is sale deed. When was the suit filed?
Suit was actually filed on 13th of December.
13/12/1982, suit filed. Right? And
It was filed on 13th.
so it was during the pendency of the suit, the sale deed was executed.
Yes, I think you can say, but the suit was not admitted by that time.
It's
He
irrelevant.
was not yet.
It's irrelevant.
Therefore, the question would be whether the plaintiff was ready and willing to perform his part. To prove the plaintiff has stated
Just a moment. Plaintiff का date of agreement कौन सा है बताइए?
Date of agreement.
no,
That is,
18
20/8 पे है.
18/9/82.
Plaintiff का 20/8 पे है.
82. Extension का date कौन सा है? 2/1.
plaintiff का
Plaintiff
limited
का
agreement है 18
पे ऐसे plaintiff का है exhibit 2.
एक सेकंड. 18/9/82.
Exhibit 2.
Exhibit 2. और exhibit 2/1?
to dispute.
और आपका एग्रीमेंट है 20/8/82. 82. This is exhibit B. Okay. And sale deed is dated 20/12/1982. Exhibit number
Exhibit G.
Exhibit G. So filed. Thirteen 12/82. Okay. That's right.
The case of the plaintiff is like this, that he has stated that the original defendant
सर जो उन्होंने बहस किया है, you are selling on the same book. उसके अलावा आपको क्या बहस?
readiness and willingness.
रेडिनेस एंड विलिंगनेस तो वो पूरा ही वही बहस किए हैं. इसके अलावा आपको क्या बोलना है?
उसके आगे वो बोले हैं कि I was always ready and still ready. अपने एविडेंस में बोले हैं कि इसके लिए एक सेलिंग के लिए वो आए थे रांची, रजिस्ट्री ऑफिस आए थे, सेलिंग पढ़े और भाग गए. उसके बाद
कौन बोला है ये स्टेटमेंट किसका है?
प्लेंटिफ है PW
4 पैरा नंबर सर आप ऐसे कैसे आप बहस करते हैं भाई? यू आर रेफरिंग टू वन स्टेटमेंट एंड आपसे पूछ रहे पैरा नंबर तो एकदम पता ही नहीं है कहाँ पर. यस मिस्टर कुमार आई एम एड्रेसिंग यू. देख रहे हैं मतलब क्या हुआ इसका? इतना लेजरली आपका सारा केस ऐसे लेजरली 50% केसेस डीएफडी हो जाता है और इसके बाद पूछते हैं तो आपको पता ही नहीं रहता कौन सा पैराग्राफ में क्या.
जी पहला नंबर लिखा है.
पढ़िए पढ़िए.
रजिस्ट्री कार्यालय में आया, स्टाम्प कागज लिखा, बिक्री नामा लिखवाया, उसके बाद वो गया. मुझे मालूम नहीं कि इस बात का जिक्र अर्जी में है कि नहीं. मुझे याद नहीं मैंने इस बात को अपने दोस्तों कहा कि नहीं. मैं उस स्टाम्प पेपर को लौटा दिया और उसका पैसा मुझे मिल गया. But he is saying that it is Jugal Kishore Pathak who got purchased the stamp paper, got the document sale deed, purported sale deed was prepared, and thereafter, after looking into the content, he fled away. Then he further states that मैं वो document को वापस कर दिया, स्टैम्प पेपर को, और पैसा हम रख लिया. अगर हम परचेजर है, परचेजर ऑफ द डॉक्यूमेंट, तो इट विल रिटर्न टू मी इफ आई सबमिट रिटर्न बैक.
परचेजर तो प्लेंटिफ ही है ना.
नहीं, परचेजर ऑफ द डॉक्यूमेंट.
परचेजर खरीदेगा कौन? जो रजिस्ट्री करवाएगा अपने नाम से वो ना डॉक्यूमेंट खरीदेगा. स्टैम्प पेपर
यही तो बोले.
बोलने से इस तरह से होता है.
जुगल किशोर
बेचने वाला स्टैम्प
कार्यालय
पेपर
में
खरीदता है कहीं?
जी
बेचने वाला स्टैम्प पेपर खरीदता है?
बेचने वाला खरीदता है या खरीदने वाला इससे नहीं कहते क्या है सो जुगल किशोर रजिस्ट्री कार्यालय में आया इस्लाम कागज दिखा बिक्रीनामा लिखवाया उसके बाद वह कैंप एंड उसके बाद कहते हैं कि इस कागज को मैंने रजिस्ट्री में जमा कर दिया उसका वैल्यू था वापस ले वो कागज को कहीं से कहीं भी एग्जिबिट नहीं कर रहा है to show his intent. Furthermore, when his suit was filed on 13/12/22, 1982, it was filed with court fee of ₹1.5.
That is not the
₹1,500.
सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं है,
Yes.
इसीलिए आप बिना सब्सटैंशियल क्वेश्चन ऑफ लॉ के बियॉन्ड मत जाइए।
Conduct show the readiness. Whether he was ready.
रेडीनेस का सूट में कोर्ट फीस देने से क्या लेना देना?
Readiness शो करता है कि उनके पास पैसा नहीं था।
अच्छा।
There may be desire, but was not ready. ₹1.5 का कोर्ट फी देके सूट फाइल किए और 83 में उसमें कोर्ट फी जमा। तो उस दिन जिस दिन वो बोल रहे हैं कि रजिस्ट्री कार्यालय आए थे और डॉक्यूमेंट पढ़ के भाग गए उसमें भी शायद ऐसा ही लिखा होगा कि पैसा सब ले लिए या पैसा बाद में देंगे। और by virtue of that sale I came in possession, I got mutated my name, I am there in the property or
ये तो प्लेंटिफ तो टेनेंट थे ऑन द प्रॉपर्टी।
plaintiff was
टेनेंट।
I was
When was the tenant evicted to give you possession?
he left the property.
Oh, he has left the
Yes,
property.
he left the property.
कहाँ लिखे हैं that he has left the property? Written statement फाइल किए थे? You claim possession and he had left the property. कौन सा पैराग्राफ में लिखा?
Depending number, उपरोक्त वाक्य मार्फत के उत्तर में प्रतिवादी संख्या को निश्चय पाठक की ओर से सभी निम्नलिखित कथन है। यह कि प्रतिवादी संख्या 3 का कंप्यूटर घटक प्रतिवादी नंबर 1 का होता है जिन्होंने प्रतिवादी नंबर 1 ने सन 1977 में अपना मुकदमा आमंत्रित कर दिया जिसका रजिस्ट्री रांची से रजिस्ट्रार में दिनांक 13/7/1977 में है और इसका नंबर सच है और वह आवेदन प्रभावकारी है जिसका फोटो इस प्रतिवाद पर अनुलग्न है इसमें संलग्न है प्रतिवादी संख्या 2 श्री राम पाठक को दिया गया मुकदमा आम को अच्छी तरह पढ़ सोच समझकर दिनांक 20/10/1982 ईस्वी को उनके साथ उपरोक्त भूमि सुधार खरीदी का करारनामा आपस में किया गया कि प्रतिवादी संख्या 3 संबंधित मकान सुधार भूमि जिसका पूर्ण विवरण नीचे दिया गया है। इनामनामा के अनुसार शेष राशि का नकद भुगतान कर 20/12/1982 को खरीद किया। यह कि प्रतिवादी संख्याती के संबंधित विभाग को अपने नाम से नगर निगम में दाखिल खारिज कर मालगुजारी मांगने का दरखास्त दिया तथा प्रतिवादी और प्रतिवादी की सुनवाई के पश्चात रांची नगर निगम में प्रतिवादी संख्याती के नाम से इस मकान का दाखिल खारिज आदेश पारित कर लगान बंद किया, जिसका फोटो इस प्रतिवाद के साथ
प्रतिवादी संख्या 3 है पावर ऑफ अटॉर्नी।
जी, it is the registered power of attorney of the year 1977.
And you are the purchaser from power.
Yes.
और कुछ बोलना है?
Then which agreement will
That's
one of the substantial question of so the earlier will earlier always the earlier will
ये जो डिफेंडेंट नंबर 1 ने जो एग्रीमेंट किया था वो भी पावर ऑफ अटॉर्नी के थ्रू किया।
हाँ, तो हम उससे एक्शन करेंगे। इसका कहीं कोई भी सीट
आपका हो गया? चलिए अब आप कैंसिल।
10:30 हम खत्म 10:39 क्या इनका रिप्लाई बस रिलाइज कर लेते हैं 10:30 कंफर्म एट फर्स्ट आप मत आइए सर
10:30 को कोर्ट शुरू होता है सर, आ जाइएगा। वैसे भी 12:30 ही बजे तक का the arguments of the appellants आप है अपीलान नंबर 1, आपका अपीलान नंबर 1, आपका अपीलान नंबर बताइए। अपीलान नंबर 1 एंड अपीलान नंबर 4।
बहुत सारा
16
The arguments of the appellants are confused. As the court time is over, post tomorrow. कल में कोई रखें फर्स्ट केस।
कल इस परसों हम काम
नहीं,
करें आज
परसों नहीं, हाँ।
हम कर रेडी
हाँ बोलिए।
एक केस है जैसे
केस नंबर
सेकंड अप्रैल 88 of 1984
84 वो होगा, ठीक है ना? For further hearing tomorrow to be taken up as first case. आज का पार्ट है, पहला केस यही है, ठीक है? ठीक है? ये सब टैग करिए, सब applicants की judgment। ये थोड़ा बहुत ठीक से रखना, कम्युनिकेशन नहीं भी है। केस का नंबर ऊपर लिखिए।
जी हम भी
आज ये
बात करते हैं।
मेमो अपनी टैग करें।
From the supplementary list, under heading for hearing, under order 41, rule 11 of CPC item 2, second appeal 100 of 2023.
The plaintiff are claiming their title on the basis of a registered deed of sale dated of the year 1958, which was executed by Roman Catholic Bishop of Ranchi. So the admitted fact is that Roman Catholic Bishop of Ranchi was the original recorded tenant. Thereafter, the original suit property in which the dispute lies, the plaintiff are claiming their title to a registered deed of the year 1995.
1958.
1958 is another sale deed. The suit property 1958 is executed for 12.24 acres. The suit property is 50 decimals, which they are claiming to a registered deed dated 22/3/1995.
Who are claiming? Plaintiff.
Plaintiff
22.
3/1995.
Just a moment. The recorded tenant name बताइए.
Roman Catholic Bishop of Ranchi.
Ranchi. They sold the property.
Yes.
Entire property.
Yes.
By the registered deed.
Yes.
1958.
7/3/1958.
To whom?
To the plaintiff. The area was 12.24 acres.
Area 12.24 acres.
This is in plot number 1 and 2, other number 17 and 31.
That's right.
Yes. And there was another sale deed executed on 22/3/1995.
By whom?
Same by Roman Catholic Bishop to plaintiff.
You said that the entire property was sold in 19.
That was portion. Suit properties with respect to 22/3/1995, which is 50 decimals.
So out of the same property,
Same.
they sold how much?
50 decimals.
In 95.
Yes. I am claiming my title was on the basis of hukum number dated 31/8/1930,
Executed by?
executed by Roman Catholic Bishop of Ranchi in favor of my ancestors.
Unregistered.
Unregistered.
1930.
I have executed Zamindari rent receipt and thereafter revenue rent receipts as well.
They are not the zamindars. Are they the zamindars?
They were the recorded tenants.
They are not the zamindars.
The rent was paid to them and that has been
That's right,
executed.
but they are not the zamindars. How do you get to write through?
Yes, I'll show. No, now the registered deed dated 17/1958, which was executed in favor of the plaintiff for 12.24 acres. In the boundary of that registered sale deed, my land is being shown that is in possession of my father. So my possession is shown in the year 1958.
You are the plaintiff.
I am the different person.
In 1950.
In 1958. Now this is an admitted fact which has not been disputed from the records. The learned appellate court came to a finding only upon an explanation made by the counsel for the defendant without adducing any evidence. There were two eviction suits as well. First eviction suit was filed by the plaintiff for eviction of my tenant, which was dismissed on the ground that there is no landlord-tenant relationship between them. And that document was executed. And there's a clear finding in that eviction suit also that the land was sold to my ancestors and which has not been challenged by them. Now, if you lordship may kindly come to the findings, sir.
Title is not decided in eviction suit.
It is not
Landlord
decided,
tenants.
but that finding has not been challenged, it has been
Need
shown in
not-
my hand and there is no landlord.
That will have
tenant
no
relationship.
bearing on title.
If your lordship may kindly come to learn page 44, just to show the findings of the.
So what is your question of law?
My question of law is that Exhibit C, which is a registered sale deed dated 1958, that shows that I am in possession of the land. So I have also pleaded adverse possession. I have given specific dates also that this is the date I came in possession. This is the date my possession became adverse. And all of these things have not been
You have
taken.
not supported it at, during oral evidence. You have just simply stated it in your written statement.
But there are documents to show that I am in possession of the land since the Hunnama was executed. And that is being reflected in their
1930.
Yes.
Where is the finding that you are in possession since 1930?
There's no finding, that is why I'm telling you. But the documents, their documents, the documents of the plaintiff, their registered deeds show that I was in possession of the land. Equal is finding. Running page 44. Second paragraph. The possession of the defendant and her predecessor in interest have been categorically denied by the plaintiff respondent. The attorney of the recorded trustee of Roman Catholic Bishop DW4 has categorically deposed that the defendant and her predecessor in interest had never come in possession of the suit land and has confirmed the position of the mission, and thereafter the plaintiff responded. The defendant appellant has admitted that she was living at Munga Hazaribagh since 1962. Here, the fact that land was left without boundary and Suleiman Kashyap's property was shown in the boundary of CAT created so and so, which has been explained by learned counsel of the defendant respondent to be of another mode. This should be my plaintiff respondent. I was the applicant, defendant was the applicant. This should be plaintiff respondent. Which has been explained by the learned counsel of the plaintiff respondent to be of another moza, Mahua Toli, do not prove possession of the defendant appellant. So two things transpire from this. The northern side of the property, my land is shown to be in possession of my ancestors, that is my father. And this has not been reverted by any piece of evidence, but only by an explanation offered at the time of argument. The claim that the plaintiff had filed an eviction suit, TS 15 of 1917, against Shivnara and Ranju, with respect to some portion of the suit land which was given in lease by the brother of the defendant appellant, and the same was dismissed, which proves possession of the land with defendant appellant. It has been contended by learned counsel of the plaintiff respondent that the defendant appellant had also filed an eviction suit, 1 of 2001, against Devnara and Ganju with respect to same land claiming to be his lessor, which has also been dismissed. Now, again, this is only an explanation, because this document has not been exhibited. Only the first eviction suit, that is TS 15 of 1997, has been exhibited, and the second eviction suit that the defendant responded are contending, these documents have not been brought on record. So to base on a finding based on documents that were not on record, false judgment process suffers from perversity.
How does they say that Hukumnama dated 31/8/1930 Exhibit J was permissive possession?
Yes, that finding is also incorrect. Because that ground could have only been taken if the suit was filed by Roman Catholic Bishop of Norwich. But a third party who is not executed the deed, Hukumnama deed for that matter, they cannot say that it was permissive possession or it was possession. Zag came in possession 1930 of the by virtue of the Hukumnama, which is reflected in their document. The same land has later been sold to the plaintiff in the year 1995.
Where is the rejection of Exhibit J? That this what is the status of this Hukumnama? What have they mentioned about this Hukumnama?
That finding is at paragraph
20?
9. The defendant appellant did not place the plea of adverse possession before the settler of the duty. She did not file objection making a claim of the property on the basis of adverse possession of her predecessor in interest. Even she had not imposed anything in her statement as a witness before the court with regard to her claim of adverse possession. The evidence led by defendant is completely silent on point of adverse possession, and we have cited in written statement without any evidence in support of his plea of adverse possession not sufficient to prove the plea of adverse possession. The defendant respondent has also failed to prove that when her admitted case is that her predecessor in interest came into possession of the land in question after the execution of the sale deed or Hukumnama dated so and so, for consideration of rupees 50 only, which was permissive possession, then how did this possession turn into hostile on or after the given date, 24/8/1943? The oral and documentary evidence available on record also does not stand in consonance with the plea taken by learned counsel of the applicant defendant that she or her predecessor in interest had adverse possession over the sultan. In the background of these facts, the evidence of the defendant applicant is not sufficient to sustain the claim of adverse possession. Therefore, the defendant applicant is also not able to establish adverse possession.
Where is your question?
C. C and E.
What the learned counsel for the applicant? This appeal is admitted for final hearing on the following substantial question of law. C and E. Which is called the learned counsel for the applicant has submitted that the defendant remained in possession of the property by virtue of Hukumnama dated 24/8/1930, which was executed by the recorded tenant, namely Roman Catholic Bishop Ranchi, in favor of the predecessor in interest, in favor of the ancestor
Yes.
of the defendant. But there is no corresponding entry in record of rights. After that also there has been survey, but that entry has not been recorded.
My name is noted at rent receipts also for the year 2005.
2005, what about 1930?
Some rent receipts. I have other vital evidences to show my possession. I was there, registered legally, then the eviction suit, in which there is a finding that I am in possession of the land.
He has also submitted that even Exhibit C showed the defendant in possession towards the north. Exhibit C dated 7/3/1958. The learned counsel has also submitted that the learned first appellate court, while recording findings, have taken oral submissions oral submissions made by the counsel for the plaintiff, which was not based on materials on record. He has in particular pointed out paragraph
Internal page 18 of the
internal page 18 of the judgment, the last subparagraph of para number 20. Issue notice to the respondents. At both the addresses, दोनों address है ना, at both the addresses given in the cost title, Two requisites will have to file. Under speed post as well as on review process. All other records will
It's an
be
ID process.
IA number 16126 of 25. Till 23rd of March. Further proceedings in execution, case number 1 of 2024, said to be pending in the Court of Civil Justice Division at Kutti in connection with the decree arising out of the present case shall be instated. Issue notice this may be or IA, both in IA and as well as the main. A date there, a day's March, post on 23rd March. You deposit special messenger cost. Special messenger cost for calling the records be deposited within a period of 1 week.
Item 3, 2nd April 30 of
There are few
2026.
new judgments on adverse possession which has come. On permissive possession also. I've seen those judgments. One is arising out of this court only. The issue was decided. The Honorable Supreme Court did not issue notice, but laid down, referred to many judgments on adverse possession. That judgment has been passed by Honorable Justice Parliament. And there is one more judgment which has come out. Let's see. There is a finding of permissive possession in this case. Yes, please.
This is against concurrent findings. Is the plaintiff and the appellant.
You are the plaintiff.
I was the plaintiff. Suit was dismissed and then I filed the appeal which was dismissed. I preferred the second appeal.
Then what is your ground? What was the suit for?
The suit was to declare right title in the suit and information possession of the suit and second to declare the deed of partition number 1843 dated 35/1966 as illegal, void and not binding on the creditors and to declare illegal mediation order class 2 illegal.
Deed of partition was sought to be declared illegal. It's a registered partition. Deed of partition was sought to be declared illegal. Who sought the declaration? One of the parties to the deed of partition. Third party.
Yes, third party to the deed of partition, which may I disclose the genealogical table. There were 3 recorded names. One is Bhula Mehto, one is Tetwa Mehto, and Bandhu Mehto.
Yes.
So Bhula Mehto and Tetwa Mehto, their legal heirs are the plaintiff appellant for a next. Bandhu Mehto had 4 daughters.
Gura Mehto and Etwa Mehto, their descendants are plaintiffs.
Yes.
No, but it is showing OP number 1, OP number 1, OP number 2. This is in title appeal.
Yes. Because Etwa Mehto's grandson has now become appellant number 1 and Etwa Mehto's second son is appellant number 2. The others of the same of Bhula Mehto and Etwa Mehto are performer respondents. Bandhu Mehto had 4 daughters. Bandhu Mehto had one son, Jolha Mato had 4 daughters. That is, Jailhar Orai, she is the main person in this variation. Jailhar Orai and 3 more, Irsi, Pabni and Kanga. Jailhar Orai, her husband is Jogia.
Now you tell us what is your question.
So, my question of law is the partition deed has been executed by Jolha Mato, son of Bandhu Mato, in favor of Jaidhar Oram.
Partition deed is never in favor of anybody.
Yes, that is my question of law.
It is always partition between
Yes.
two persons.
So all the other 3 daughters have not been given share. The share of Jolha Mato has not been shared. The recorded tenants are Bura, Etwa and Bandhu. There is no document to prove that the lands have been divided and Jalha Mato had his share defined. No formal proof, no registered partition, no oral partition. There is just statements of convenience, partition on basis of convenience, which has not been proved by formal documents. Jolha Mato,
Where is the trial court degree?
degree, page 42.
What is the finding on the point of limitation? Issue of limitation was strained?
Yes.
What is the finding?
We said we came into knowledge of the partition deed in 19.
You said what is the finding?
That issue is not. There is some discussion on it, even in the plain and Yakura stage. That since we received notice of an empty case of 1999, we then came into knowledge of the partition deed of 1966, and then we filed this case.
What is the finding on issue number 4 and 5?
4 and 5. 4 has been decided in my favor at page number.
Okay, you are guided by customary.
Yes.
What about 5?
5.
If you are guided by customary law, then daughters are not entitled to.
This judgment is almost on multiple fronts. It is the same because the partition deed, well, it's not a partition deed, it's more of a gift or relinquishment deed. It's not a partition deed. And but that partition deed has been that partition deed has been executed in the name of the daughter. And one of the issues on the entire case of the defendant was that the husband of the concerned daughter was kept as a will. But the deed has not been executed in name of the daughter. It has been executed in name of the daughter. And the finding has come that customary law is in favor of the plaintiffs. And that the female do not have right of defense. And the other 3 daughters, their shares are not disclosed. The person who has executed the partition deed, his division of share is nowhere exhibited, nowhere mentioned. There is a discussion ground of allowing the title suit and the appeal against me has been that section 46 of the CLT Act is not applicable as it is a partition. Therefore, my submission that it is not a partition. And
You see, the partition deed was challenged in the suit by the plaintiff. You say that section 46 of the CLT Act,
no prior permission was taken by the
no prior permission was taken. So that goes in favor of the plaintiff only.
I am yes. Yes. So it should go in my favor, but they have instead it in the sense saying that since it is a partition deed and the words used in section 46 do not cover partition, therefore. So my argument is just since the title of the document is a partition deed does not mean that it is a partition deed. The other shares are not exposed. It's a gift or a relinquishment deed. Its shares are transferred to a person who, under the finding of trial court, is not able.
Where is the discussion about the nature of the deed, partition deed? What is the content of the partition deed?
That is
Where is the discussion on that? Partition deed was exhibit?
yes. Partition deed is exhibited C as well as exhibit 3. Page number 27 is page 3 of the record. WS on behalf of Jyotia Mara, husband of deceased defendant, was filed challenging the suit on the ground that the suit land was jointly held by the authority, which was partitioned in between them in the year 1966. 1966 is the year when partition was in the second not between the recorded periods. The father of original defendant Jharkhand, one of the recorded periods, had amicably partitioned the joint property and thereafter he came in possession over the suit. The defendant's contention is that Jharkhand, the recorded period, had no main issue and therefore with the consent of other shareholders, he adopted a Jharkhand, who was married to his daughter Jharkhand in form of Jharkhand. Jharkhand died in 13 June 2003 in the house of her father, and after that her husband was included as a party.
Was it your case before the trial court that this deed is not a deed of partition?
That deed is illegal.
Where is it? That this deed is not a deed of partition.
That it is an illegal void and is not binding.
That is not sufficient. This deed is not a deed of partition. Where is your case?
My case is that no partition had taken place.
That is a separate thing. That is a separate thing altogether. That no partition had taken place.
Section 46 issue came only after the trial court's judgment.
No, it was there even at the time of
issue was not framed as to whether section 46 was
clarify. That was your specific case, even if the issue was not framed. That was the specific case.
That is a
That the plaintiff's cases that he had no knowledge of partition deed dated 3566 till 6/1/2000. The same deed was illegal and not binding upon the plaintiff because no partition had taken place. Before partition, previous sanction of the DC for transfer was not obtained. That was your specific case. So, where is your case that this deed is not a deed of partition at all?
my case is the trial court came up with the logic that since section 46 requires 2-3 requirements.
You came up with a plea.
My case
It was your case, specific case, that there is no sanction for transfer. That is why there was occasion for the trial court to come to any finding on that.
For the transfer, I say that the deed is a form of transfer, and therefore section 46 is applicable.
Where is the discussion about the content of the partition deed? You say that it's a transfer deed.
I say by the content. Because
You have got a copy of the partition. Where are you reading it? Not legible. It is a registered document. You say it is not legible.
Because nowhere in the entire discussion of both the courts has it mentioned that what is the share of other three daughters. It's a partition deed by the admission of defendants.
Three daughters will not get any share, no?
They
They are not entitled to a share.
The court did not had the deed been executed in name of the Ghardamar, it would have been a different case. The deed has been executed in name of the daughter. So there is no reason that the other three daughters are excluded. Unless it was the self-acquired property of Bandhuara, who can then transfer it by way of will and then it can be proved. This is a case of transfer, and therefore no sanction being taken is a valid ground for it not to be considered.
There is a question of law with regard to interpretation of Exhibit C. Which one is the question?
That is exhibit question D and E. Page 3.
What the learned counsel appealing on behalf of the applicant? The learned counsel for the appellant has submitted that though the plaintiff has lost in both the courts, but the partition deed, registered partition deed, which was subject matter of challenge before the court, was not a partition deed, but it amounted to transfer. And therefore, prior permission from the Deputy Commissioner under Section 46 of the Jharkhand Tenancy Act was required. And in absence of such permission, the so-called partition deed is itself null and void. Submits that this aspect of the matter has not been properly considered by the court, and therefore substantial question of law arises for consideration. He has also submitted that in absence of any partition amongst the recorded tenants of the suit land, there could have been no partition deed with respect to only one branch amongst the three, right?
Yes.
There is no finding of previous partition. The learned counsel has also submitted that there is no finding of previous partition amongst the three sons of the recorded tenants, namely Dude Orao, Etwa Orao, and Bandhu Orao, and the partition deed is only relating to Bandhu Orao. Correct? He has referred to substantial question of law number B, D, and E.
C also.
It's the same thing. B and C is the same thing. You choose either of it. B and C is the same thing. This appeal is admitted for final hearing on the following substantial question of law B, D, and E.
Which may I just get this partition made is with respect to Jharkhand, who is the son of
The partition deed is in respect of Jalhe Oraon, son of Bandhu Oraon. And Bandhu Oraon was the son of the
Bandora was there.
Bandhu Oraon was a recorded tenant.
Three recorded units, Mura, Etwa, and Bandhu.
Bandhu Oraon was one of the three recorded tenants, and all of them were son of Sukhbir Oraon.
They have different parents. They have different fathers.
Previous partition किसके बीच हो?
There is no
And why this third substantial question of law, this B is there? I will not frame B then.
previous partition should have between Mura, Etwa, and Bandhu.
Their share was not segregated.
The rent receipts that are exhibited, it has the name Bura Mehto Bagera, Bura Mehto and others.
ऐसा लिखिए ना. The suit land was recorded in the name of Bura, Oraon, Etwa Oraon, and Bandhu Oraon. And the partition deed has been executed by Jhale Oraon, son of Bandhu Oraon. And upon true construction of the deed, the same amounts to transfer in the name of the daughter of Jhale Oraon. Correct? Daughter was the dependent.
Yes, original defendant, she died and
Daughter Jaidhar Oraon was the original defendant, and upon her death,
her husband and two sons.
her husband and two sons were substituted.
The husband has died, has been substituted, so two sons are there.
The husband has also died,
The name has been
and her sons are the appealant before this.
respondent.
Sorry, other respondents before this. ठीक है, ये 3 substantial question आपको. Issue notice to the respondents. Issue notice to the respondents so far as respondent number 4 is concerned. No requisite be filed as he is to be represented by the office of learned advocate. Counsel for the appellant is directed to serve 2 copies of the memo of appeal with enclosure and synopsis in the office of learned advocate general so that an appropriate counsel be appointed to assist this court. The requisites for service of notice upon respondent number 5 and 6. Sorry?
5 and 6 upon my list, 2, 3, 2, 3,
Okay.
5 and 6.
2, 3, 5 and 6. Through the concerned police station be filed by the appellant within a period of 1 week. The records of the concerned courts be called for upon deposit of special messenger post by the appellant within a period of 1 week. Yeah. Let this order be communicated to fax. Post on 24th March.
From daily list, item 36, second appeal 19 of 2023.
Main concept is that after there is not present. They have moved the arguments to yesterday. Allegate in the next week.
Essay number 19 of 2023. A petition seeking the advance notice seeking adjournment has been circulated. The counsel for the appellant seeks adjournment on account of non-availability of arguing counsel Mr. Rahul. At his request, the matter is directed to be posted on next Tuesday by way of last intelligence.
Item 37, second appeal 50 of 2023.
Case of reversal management. Here there was a confusion, my leadership. This was filed as a miscase, but then now it is being divided into the second application. My leadership in this, the arguments hearing, we are the degree holders in a suit for specific performance. There was an agreement, my leadership, in which we were one of the parties, and the other party was one lady named Kohli Devi. She was the sole respondent in the suit for specific performance, and that suit had been declared in our favor. After
Who was the
that,
sole respondent?
one Srimati Kohli Devi. And this Tapan Kumar Mitra, who was the plaintiff hearing and the appellate hearing, they were the plaintiff in that suit. That was decreed in our favor. And in the execution case, an application was filed by leadership. It is mentioned that under Order 21, Rule 97.
By whom?
By third persons who are not party to the suit.
They have a notice.
Validation, but if just for 1 second, if Order 21 Rule 97, where this notice was, where this application was filed, if just for 1 minute, if it can be read by nature.
It has to be filed by the party to the
Yes, Manisha, the decree holder has to file it. Only the decree holder or the person to whom any such property in execution was sold to, only they both have the right financial. And this is
Third party does not have the right to object.
not in this order.
Anyways, provision of law will not decide on it. But the third party has right to object. You cannot say that he doesn't have a right to object.
This violation. So they were filed, this application was filed and that was rejected violation. And then to that a civil appeal was filed, that has been
Rejected on what ground?
rejected on the ground that the persons, the third parties, so they were the nephews of this holy lady, and one of the persons, the applicant's own brother, one Shivputran brother, he himself was a witness of that agreement also. So it is not possible that they did not know about the civil suit or the execution case in that.
No, need not. If they are not party, they are not parties. And what is the finding?
It is at page 28 on 26 on the web. The civil proceedings case 18 of 2018.
Objection has to be adjudicated.
This matter it was adjudicated by nature.
There is no merit in this. It will be adjudicated. No, it was not adjudicated. Keeping into consideration all facts and circumstances as discussed above, the instant civil appeal is allowed and the order impugned of the executing court is set aside, directing it to adjudicate the objection. The court has to adjudicate the objection. There is nothing.
It has still not been adjudicated.
It will be adjudicated. You are seeking time in the court. That is why it has not yet been adjudicated. Okay, essay number 50 of 2023. The Learned Counsel for the Appellant has submitted that the appellant is a decree holder in the suit for specific performance of contract against the sole defendant, namely Kaili Devi. At the stage of execution, her objection was filed on behalf of the applicant Satyanarayan Gop, which was opposed by the decree holder. The applicants claimed to be the rightful owner in possession of land. By virtue of a registered city. The objection was not adjudicated. And it was observed that the case record revealed that the applicant had filed original suit Hearing number 426 of 2007, seeking the relief of ownership of real property. They are observing that in the agreement, the brother of Koili Devi was one of the defendants, and therefore it will be presumed that the applicant had very much knowledge about the proceeding, but they never appeared before the trial court. During the course of hearing, it is not in dispute that the applicant was not a party in the suit. The sole defendant was Kali Devi. The said order was challenged by the applicant before the first appellate court, and the first appellate court has set aside the judgment of the trial court, rejecting the objection of the applicant, and has directed the executing court to adjudicate the objection raised by the applicants. It was numbered as civil miscellaneous case number 18 of 2018. Admittedly, the objection was dismissed at the stage of admission. This court has gone through the review judgment. And is of the considered view that the objection raised by third party was required to be adjudicated. And the learned trial court has wrongly refused to admit the miscellaneous case, and the learned first appellate court has rightly set aside the order and has directed the executing court to adjudicate the objection. In civil miscellaneous case number 18 of 2018, this court is of the view that no substantial question of law is involved in this case. Accordingly, this cannot be dismissed.
Item 38, second appeal 64 of 2023.
I'm reading the trial court judgment also. Page 14.
Page
Page 14.
1
40.
Yes, please.
The suit has been filed for the original plaintiff, Ganesh Prasad Singh, deceased, and the declaration of the registered sale date number 16 of the 226, dated 7/1/2026, illegal without consideration fraudulent which was executed by the defendant. The plaintiff further stated that the defendant wrongfully without any authority, illegal without jurisdiction, tempted by God and his representation executed the sin, which is null and void ab initio. He also pleaded for the confirmation of possession is alternative recovery of possession besides other degree. But the brief story of the judgment.
No, what is your, you have lost in both the courts?
Yes.
What is your substantial question?
Substantial question is the partition has not been built between the parties. Lordship, the defendant is the purchaser, Lordship. And the plaintiff has sold the ancestral property without the partition.
You can say that undivided portion of property, you can always say.
But Lordship, one judgment, Lordship, and this Vinita Kumari Lordship is Rakesh Sarma case. It is clearly stated. We reiterated that the plea of an older parties or the memorandum of parties. I am reading the Lordship judgment. Exactly.
What are the issues straight? Let us see the issues first.
On the page 6, Lordship, page 44 of the trial court judgment, Lordship, issue number 5 and 6. If the registered cell deed number 216 of the 2006 dated 7 January 2000 executed by the plaintiff by way of fraud and misrepresentation, therefore a wrong, unquote illegal, without consideration, hence null and void, or if the plaintiff entitled for confirmation of the person for the suit. That is the true, it is the necessary is Lordship, but it is go against me, Lordship.
You see, you have not been able to prove that it was illegal, void, and it was by misrepresentation. These facts have not been proved.
Without partition, he has
That is a separate thing. But so far as whether this is by fraud or misrepresentation, that is not. That has you have not been able to prove.
Yes, Lordship.
So, which judgment are you relying?
Yes. 2020, volume 9, SSC, page number 89. I am reading the 7th line.
Yes.
Page number 89. We calculated that the plea of an owner partition or the memorandum.
Page number 89.
Yes, Lordship.
Para number?
Para number A.
Para number 8.
Para number 135.
135.
Page number 89 also. The second page also. I am reading the second line also. We reiterated that the plea of an older partition or the memorandum of partition unregistered, one can be manufactured at any point in time without any contemptuous public document need rejection at all costs. ओनर पार्टीशन को करता ही है कि लॉर्डशिप की कभी भी कर सकते हैं.
Oral partition has been now totally rejected by the court.
लॉर्डशिप
Not all the oral partitions. This is basically for the purposes where a daughter is deprived of the property by virtue of oral partition.
but there is
When is the
every partition had he is saying the every partition, so I am saving the land. How it is possible?
is there any finding that there was no amicable partition?
Yes.
Consider. Essay number 64 of 2023. The learned counsel for the appellant is present. As the court time is over, the argument has remained inconclusive. However, the council has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2020, bracket 29 SCC. Page number?
Page number 89 also.
Page number 1 at paragraph number?
Paragraph number was 35.
Paragraph?
135.
Paragraph 1. ठीक है? ये दे देंगे